And the way that I can do that is by dangling a jailhouse key in front of you. So you hold the keys to the jail, and the first time you falter, I will yank the bond, and I'm going to put you in jail. You now know that you have no one to bond you out. So if you go to jail, you will be stuck like Chuck.
On April 29th, 2024, in Harris County, Texas, a man known on the record as Mr. East was charged with making a terroristic threat against the mother of his child while already serving deferred adjudication probation for assaulting a pregnant person. The complainant in that earlier case, his own sister. Now he stands before a magistrate in custody asking for one more chance. Mr. East has been on deferred adjudication probation since January of the prior year. He also carries a prior assault family violence charge refiled in November 2022. Defense counsel, referred to as Carl, is pushing for a bond reduction or a PR bond. The DA's office has already flagged the probation court, which may move to adjudicate. The new allegation, Mr. East threatened to kill the mother of his child in front of their child. He later admitted it to police, calling it a moment of anger. Three legal frameworks are at play. Under Article 17.15, the magistrate must weigh victim safety alongside flight risk. It's not just about showing up to court. Under Article 17.03, a PR bond is fully discretionary and rarely granted when a defendant is already on probation for violence. And under Article 42A, 101, deferred adjudication is a trap door. Pick up a new case and the state can yank the deal entirely and impose the full sentence. That original probation, assault on a pregnant person, a third-degree felony, 2 to 10 years. Mr. East just handed the state a loaded gun. This is why the magistrate is taking this hearing so seriously. And this is why what he proposes next is so legally unusual. Let's go to the footage.
Bond, they did not grant him a PR bond, mostly because he's on deferred out of the 232nd District Court for assault on a pregnant person. That's a different complainant. The complainant there was his sister. So
hold on, you want me to bring him out?
Sure.
Stephen, do you mind bringing someone out, please? Yes, sir.
I was just giving you a little preliminary before you brought him out.
I want him to hear it.
I understand. But he went to probable cause court. They denied a PR bond. He does have family here, and he is employed. And we're asking the court either for a bond reduction or for a PR bond. He's been on deferred since January of last year.
Manuel?
And the assistant district attorney's already notified them that he has this case. We're not sure whether or not they're going to file a motion to adjudicate or not, or take any action.
Hey, he's in the holdover because it doesn't help.
Yes, sir.
Several legally significant things just happened in that opening exchange. First, defense counsel laid out the procedural posture cleanly. $5,000 bond, no PR bond granted, and crucially, the reason. Mr. East is on deferred adjudication out of the 232nd District Court for assault on a pregnant person, with his sister as the complainant. That is not background noise. That is the central legal obstacle to release. Second, the judge made a deliberate choice that tells you everything about his judicial philosophy. He stopped defense counsel and said, in effect, "Bring the defendant out, I want him to hear this." That is not procedural housekeeping. That is a magistrate signaling he intends to address the defendant directly, personally, and on the record. In Texas magistration practice, this is a judge who treats the bond hearing not just as a paperwork exercise, but as a moment of accountability. Third, the prosecutor flagged that the DA's office has notified the probation court, meaning a motion to adjudicate under Article 42A, 108 is on the table. That's the sword of Damocles hanging over this entire proceeding. Now, Mr. East is brought into the courtroom, and what follows is one of the more unusual judicial colloquies you will see on a magistration record. Watch what the judge says first.
Yes, sir.
East.
Yes, sir.
How's jail?
To be honest with you, it's not nice.
Great.
It's not nice at all. And
That makes me very, very happy because I hope it's one of the most miserable, rotten experiences that you ever had.
It is, sir. And I wish to never see it again.
The problem is you keep doing things to land you in there.
Yes, sir. And I will try my best to do more to not end up back in here, sir. I promise.
The road to hell is paved with good intentions, Mr. East.
I know, sir.
You're on a very serious probation for assault of a pregnant person. And now picked up terroristic threat. You're now facing another year in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, sir.
You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes,
I don't
sir.
even know what happened to your case. All I know is that you're on a serious probation,
Yes, sir.
and now you've picked up another case. So let's see what happens
Yes, sir.
and whether you deserve to be let out.
Yes, sir.
Please.
On April 29, 2024, in Harris County, Texas, the defendant threatened to kill the complainant and the child that they shared together. Complainant felt in fear and pepper sprayed the defendant while on the phone with the 911. Defendant admitted to the threat, stating it was out of anger.
The magistrate did something the code doesn't require, but doesn't prohibit. He looked at Mr. East directly and said, "The road to hell is paved with good intentions." Then came the Article 15.17 warnings. Charge: right to counsel, right to silence, right to terminate any interview, right to an examining trial. By the book. Then the affidavit. Mr. East threatened to kill the mother of his child in front of their child. She pepper sprayed him mid-911 call. He admitted the threat to police, blaming anger. That admission is devastating. Under Texas Penal Code 22.07, a terroristic threat against a family member is a state jail felony. Mr. East's own words just built the prosecution's case for them.
What do you think? What other does he have any other prior criminal history from anywhere else, juvenile?
So, Judge, his priors are all in county. He has assaulted a pregnant person that he's on probation for against his sister, and an AFM, which was, it looks like it
So
was.
he has another assault.
He has an AFM from 11.
22.
I think it was the same.
It was refiled. So it was an AFM that was refiled to assault a pregnant person.
That was his sister. The complaint was his sister.
Correct.
Not the
Complainant
same
on that
complaint.
case was his sister, and the complainant in this case is the child of, or the mother of
His child. He's not compensated, baby mama.
Yeah, try not to. Did you make it?
Mr. East, what do you do with your life now?
Right now, I'm working at a thrift store. I'm not getting paid that much, but I'm getting paid just enough to take care of the child. And right now,
How are you going to take care of a child? You can't even take care of yourself, Mr. East.
I'm still learning. This is my first child, Your Honor. This is my first child, Your Honor. And
You know, the problem is that with all the anger that you have, if a child sees it, what are they going to do?
they're gonna feed off that same energy, sir.
Right.
And
They're going to be just like you.
thank
If
you.
they see you beat mama, threaten to kill mom, what are they going to do?
Same thing, but I would never touch my mother, my child's mother. I would never. I would never.
Patient for the very same thing, Mr. East.
I understand, sir.
I don't know, Carl.
One fact changes everything. This man already caught a case for assaulting a pregnant woman, his own sister, then a separate family violence charge, and now he's threatening to kill the mother of his child. That's not bad luck. That's a pattern, and the judge is required by law to look at exactly that. When the magistrate asks, "Can you even take care of yourself?" that's not small talk. He's building a paper trail. Bond decisions can get appealed, so the judge is saying his reasoning out loud. On record, a child watching all of this gets damaged too. He's thinking 3 steps ahead. Then Mr. East looks up and says, "I would never touch my child's mother," except he already admitted to threatening to kill her, to the police. On record. The judge hears it. Doesn't call it out. Not yet. But that contradiction is now sitting in the room like a ticking clock.
I don't know. You know, I'm not,
He's a lifelong resident of Harris County, Your Honor. He's not a flight risk.
I'm not, my concern is the public.
I understand. And the conditions are right now, he does have a place to stay. He lives on Tidwell. The mother of his child lives at a different location. And he orders are here for him to not have any contact with either with her, the complaining witness.
What was the tipping point here? Why did he get so angry?
4 o'clock in the morning,
4 o'clock in the morning.
I had got a phone call from a girlfriend of mine because she was having some problems of her own, but I was sleeping and I didn't hear her phone call or her texts. So while I was holding the baby, I asked her.
4 in the morning.
4 in the morning,
Yes, sir.
I believe he responded to some text from another female judge, and that's what caused the altercation between him and his mother of his child, which is understandable. We've talked about this. But he did not assault her, and as a matter of fact, he was pepper sprayed himself during the course of the altercation after he made the threat. He admitted to the officers that he made the threat out of anger. He had no intention of following through on it. He is gainfully employed. He just started his job last week. Hopefully he still has it. He hasn't been bond forfeiture for. He's not failed to appear in court. He's not a flight risk.
I'll make you a deal, Mr. East.
Yes, sir.
The only way, because I think that everybody should be given a chance.
Yes, sir.
You weren't given a chance here. You're on probation, which is a serious.
Charge.
What I want to see, though, is you proactively addressing your anger.
Yes, sir.
The only way I will let you out is if you take it upon yourself 3 times a week
Yes,
to
sir.
do anger management classes somehow, some way.
Yes,
And
sir.
I want proof on a written piece of paper that you're actually doing some kind of anger management
Yes, sir.
3 times a week.
Can we make it 4 times a week? I'm sorry to interrupt you, Judge.
3 is sufficient.
You need to do something that's realistic.
Yes, sir.
Don't overkill because you're setting yourself up to fail.
Yes, sir.
All I want is you to address it. And the way that I can do that is by dangling a jailhouse key in front of you. So you hold the keys to the jail. I want you to do 3 anger management classes a week.
Yes, sir.
And I want you to bring it proof to me every Monday that you've done 3 classes a week.
Yes, sir.
And the first time you falter, I will yank the bond and I'm going to put you in jail. You now know that you have no one to bond you out. So if you go to jail, you will be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir. I understand.
Give you this one and only chance.
Yes, sir.
Make me proud. Don't fail me.
Yes, sir.
So we need to find some kind of anger management class. I'm sure that there are free ones. It is up to you to find it. It's not up to Carl. It's not up to your girlfriend, not up to
Yes, sir.
you.
Yes, sir.
And I want you here every Monday with proof in hand that you've done the anger management classes.
Yes, sir.
3 week. No dope, no alcohol. Carl, I'd like to know who the extramarital person is, and we need to cut that off so that there are no reasons for her to get upset or you.
Yes,
You
sir.
focus on one and you focus on that child.
Yes, sir.
Understand?
Yes, sir.
This is the only chance you're going to get from me. You will not get another one. If you don't believe me, look around.
I believe you on. I believe you on.
Jeez, make me proud.
Yes, sir.
Judge, do you want him to have no contact with the complaining witness, or do you
I would
want him to
say
have no
until
contact?
things are better, yeah, no contact and no weapon.
Present time.
Yeah. with this one and the other probation case as well. Yeah.
I understand, but
Yeah.
other probation case, the complainant there was his sister. You want no contact with her also?
Yeah.
Okay, fine. Just want to make sure he,
It's probably already a condition of the felony probation. That's
well, I
it.
understand. I just want to make sure that he understands while he's here.
It's already stated that I shouldn't have contact with Malaysia triplet or have any.
Stop. You know what's expected of you.
Yes,
That's the only thing that matters.
sir. Thank you, Your
Thank you,
Honor.
Your Honor.
Thanks, Carl.
On the bond, is it a PR or a reinstatement or?
No, it's a PR because he never got a bond
I
whatsoever.
wanted to make sure.
Yeah.
Come on.
Thank you, Judge.
Okay, Carl, thanks.
The judge didn't stop at anger management. He stacked 4 conditions on top of each other: no contact with the mother of his child, no contact with his sister, no weapons, and a personal directive from the bench to end the relationship that started this whole 4 a.m. situation. Can a judge legally tell you who to date? Not exactly. But he can attach any condition tied to community safety under Article 17.40. That's exactly what he did. And violating any single one of these conditions isn't just a bond problem, it's a brand new crime. Then came the ruling. PR bond granted. Mr. East walks out without posting a dollar. But don't mistake this for a win. He is now living under 3 overlapping legal frameworks simultaneously: his existing probation, this new bond, and the protective orders. Any one of them collapses. They all collapse. The DA still has the terroristic threat charge. The probation court has been notified. A motion to adjudicate hasn't been filed yet, but it's loaded and ready. The judge put it perfectly. He's holding the keys to his own jail cell. 3 anger management classes a week. Proof submitted every Monday. No contact, no weapons, show up. That's the entire assignment. What happens next has nothing to do with lawyers or judges anymore. It's on him.